It was a very, very important decision by the Supreme Court today, but almost nobody's gotten it right. Not because I'm special, but because I read it. It's about 180 pages long, and it deals with first principles. It deals with a matter the Supreme Court has never considered before. When does a congressional recess actually occur, and when can a president make a recess appointment? A number of groups filed amicus briefs. Landmark Legal Foundation did. Sekulo's group did. We weren't the main litigants. The main litigant was a man by the name of Noel Canning, and he was represented by a lawyer from Jones Day, Noel Francisco. And that law firm and that gentleman asked us early on to provide him with advice and support, which we did. And we've been involved in this case from day one. And now I want to tell you what it's about in some detail. We've talked about this case before when it was first ruled on by the Circuit Court in Washington, D.C., but the Supreme Court has fundamentally altered this provision in the Constitution. So here's the way you look at it. What was the holding in this specific case involving Obama and his appointees and so forth? 9-0. But what else did they say in this case that resulted in 5 justices going one way and 4 justices going the other? And this is what is being completely ignored, except by those of us who actually understand the Constitution. Here's a little background. Noel Canning is a small bottling company in Yakima, Washington. It was adversely affected by a decision from the National Labor Relations Board and challenged the validity of that decision by alleging that the members of the board were unconstitutionally appointed because they were purportedly recess appointed during a pro forma session of the Senate. What is a pro forma session of the Senate? That's when the Senate is technically still in session, even though it's not really conducting business. Every now and then, maybe at noon, they'll have a vote. Some of the members will be there, some won't, a quorum call. But the Senate and or the House technically stay in session. Noel Canning was represented by Noel Francisco, an attorney for Jones Day in Washington, D.C., and Landmark worked closely with Noel Canning's lawyers at both the Circuit and Supreme Court levels. And so this case was argued by and represented by Jones Day, the law firm in Washington, D.C., and Noel Francisco in specific. And we were an advisory role from day one. The Constitution creates a shared system of the appointment power between the Senate and the President in Article 2 of the Constitution. It's called the Appointments Clause. Under this clause, the President may nominate people for positions as federal officers or judges, but these nominations require the advice and consent of the Senate for appointment. It's quite clear from Madison's notes that the framers feared and did not establish an all-powerful executive. And so this is part of the checks and balances of the process. Crucially, this is part of the separation of powers process. The Constitution, however, provides an exception to this system of shared power, the Recess Appointments Clause. Now here's the exact text of the Recess Appointments Clause in our Constitution. Quote, "The President shall have power to fill vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session." Crucially, vacancies that may happen during the recess of the Senate. The recess. Not the multiple recesses, the recess of the Senate. Now, one of the reasons they did this was because Congress didn't meet as long as it meets today, and many of them had long distances to travel, and so there was some concern that the President be able to conduct executive branch business while they're traveling, while Congress is out of session. And out of session means between sessions of Congress. That is, you have one Congress, you have another Congress, you have another Congress every 2 years. Now, there were 2 fundamental questions raised in this case before the Supreme Court. First, what does the recess mean? The recess. Does it mean solely the recess between the formal sessions of Congress? Or does it apply more broadly to the frequent and often shorter periods of adjournment within sessions? You know, when they take vacations, or maybe they'll close for lunch, the holidays, what have you. That's called an intra-session. Between sessions of Congress, the more formal, longer periods, they're called intersessions. Second, what does happen may happen during the recess of the Senate. What does happen mean in the context of vacancies? Does it mean only those vacancies that arose during the recess? Or does it apply more broadly to vacancies that occurred at some point during the prior legislative session and that continue to exist in the recess? Here's the point. Maybe Congress, and specifically the Senate, doesn't want to act on an appointee, on a nomination from the president. And then they go into Christmas recess. Not a session between Congresses, but Christmas recess. And then in order to get around the appointments clause, the president appoints his nominee to a recess appointment when they're on vacation in Christmas. Is that what the Constitution intended? Clearly it's not, but that was one of the questions raised. You with me, Mr. Producer? I'm trying to take this step by step. All right. So you see, it's not as black and white as some would have you believe right now. Just stay with me. So to clarify the distinction between intersession, that is sessions between Congress, these formal sessions, and intra-session recesses, that is the shorter sessions, the break is less formal. You know, it's an adjournment of any type that lasts until the next time the Senate convenes. They go for Christmas, they go for lunch, whatever. Well, which applies and do either apply? Now, the court ruled 9-0, every justice, that Obama went way over the line. That when Obama made his appointments to the National Labor Relations Board, Congress was not out of session. Any session. Not intra-session, not intersession. Congress was technically in session, conducting votes now and then, and that's when Obama decided, well, I'm unilaterally deciding you're out of session, you're not really conducting business, so I'm making these appointments. Now, ladies and gentlemen, at the time we talked about this, at the time, Landmark and I got involved in this case immediately because it was one of the most egregious acts by a sitting president ever in an attempt to eviscerate the separation of powers in this respect and the appointments clause. So, the court ruled 9-0 that those appointments were invalid. They violated the Constitution. Now, Justice Breyer wrote the opinion of the 5-justice majority. Joining him were Kennedy, Ginsburg, Sotomayor, and Kagan. Then there was the concurrence, written by Scalia, joined by Roberts, Thomas, and Alito, and they only concur in the outcome of the case as it affects the Obama violations of the Constitution, the Obama appointments. But those 4 justices disagreed vehemently with the rationale applied by the 5-justice majority. And this is where the ball's been dropped all over the media, all over radio, all over TV. And it's important because beyond Obama, there will be other presidents who try to pull these stunts. Breyer, who wrote the controlling opinion, ruled the appointments improper because they were made when the Senate was actually in one of these pro forma sessions. The Senate is in session when it says it's in session. So Obama can't make recess appointments when the Senate says it's in session. That's consistent with the Constitution's broad delegation authority to the Senate to determine how and when it conducts its own business. Great. But Breyer and these 4 other justices completely rejected the constitutional text and originalist interpretation of the recess appointments clause. They held that the recess appointments clause empowers the president to fill any existing vacancy during any recess, intra-session or intersession of a sufficient length. Well, what does that mean of a sufficient length? We don't know. We don't know what that means. They don't know what that means. Means there'll be more litigation in the future. So that 5-justice majority, they held that the president can make these appointments when Congress takes a vacation. We don't know how long the vacation is to be if they're not in session, as opposed to the more formal and longer periods between sessions of Congress. Now, the text of the clause reads, again, the president shall have power to fill up all vacancies that may happen during the recess of the Senate. These 5 justices rejected the plain meaning of these terms, the recess, holding that the language is ambiguous and could mean any type of break of substantial length. Here's a quote from Breyer. In our view, the phrase the recess includes an intra-session recess of substantial length, Its words taken literally can refer to both types of recess. Of course, that's false. He rewrote the clause. So what Breyer did is he turned the Constitution on its head. You see, ladies and gentlemen, prior to 1945, those kinds of appointments were almost never made. From 1945 on, 90% of these intra-session appointments have been made. But the Constitution's clear. So for about 150 years, give or take, from the time of the establishment of our Constitution, the President and Congress understood what the recess meant. So Breyer could not provide a principled boundary to what constitutes a recess of sufficient length. So what did Scalia, what did the four-justice concurrence, what did they say about the language in the Constitution?